In case you just joined us on Inside Pages, we're looking at that defamation suit that has been thrown out. It was filed by Ace investigative journalist that's now just announced announced against a sitting member of parliament for the Asin Central candidate Ohene Ejepon. Now, this matter has actually taken social media and also media by storm. It's got all of us talking about the future of even investigative journalism or journalists. So what we intend to do this morning is that we will be playing you excerpts of what happened in court or the precincts of the court where the action happened. And then afterwards, we'll also play you the president, that's His Excellency Nana Addo Dankwa Akufo-Addo's tape where he talks about the fact that he will use the ANAS principle in fighting corruption. So we have all of that. And also we want to know what Ghanaians make of what has happened to Anas Arimeyao, or what they make of the court ruling as well. So we have all these tips for you. When I'm done with that, I will then be introducing my resource persons to join me in the studio. So let's proceed.
Yeah, thank you very much. You have specifically mentioned corruption within the taxation system. What exactly will you do to stamp this out?
The measures are going to be difficult, but there have to be a variety of them, including what I call the ANAS principle, setting up highly motivated professional groups of young people who will work, if you like, as it were, undercover to unearth examples of corruption wherever they can find it, and thereby allow the authority to deal with the issue. Because not only do you unearth the corruption, but you actually deal with it in terms of sending people to court, prosecuting them. Hopefully the courts will cooperate and make sure that the offenders are found guilty and sanctions appropriately enforced. So a variety of measures, but a key one is the ANAS principle, as well as, of course, what you do to securize those who are in the tax collecting agencies.
The evidence, according to the court, proved that those who were able to pay the sums of money demanded by Anas and his associates were exempted from videos that were shown to the public. The court, in its wisdom, concluded that what Anas is engaged in is not investigative journalism, but rather investigative terrorism, and that the Member of Parliament of Asin Central was justified to call Anas a blackmailer, corrupt, an extortionist, and evil. In his submission, Justice Eric Barr indicated that since the award of costs in such civil cases is at the discretion of the court, he will award the costs of 50,000 Ghana cedis against the investigative journalist Anas Arimeyao Anas. Speaking after the hearing, the Asin Central Member of Parliament, Kennedy Ejepon, has said his victory against investigative journalist Anas Arimeyao Anas is a victory for former president of the Ghana Football Association.
The victory is for the victims of Anas, the people, the good people of this country that Anas has destroyed. All those people who were sacked from their jobs, the people who have died through Anas' illegal investigation should be compensated. Compensation is not enough. He has to apologize to his victims. And today, I say to Ghanaians that we have to be bold to speak the truth in this country. A criminal like Anas, who goes out there to defame people to enrich himself. It is only this country that a journalist will cover his face to go and give witness. When a whole Supreme Court judges are sitting there, and 3 young men have covered their face, testifying against their own colleague judges.
In 2018, the investigative journalist sued the aspiring flag bearer of the New Patriotic Party for allegedly defaming him. It was the prayer of Anas Arimeyao Anas that the court awards 25 million Ghana cedis against Kennedy Ejepon as compensation.
Okay, Anas is a good person and he has been doing a good job for us because there are some things that we don't know what is going on in Ghana. Maybe there are some things like it can happen somebody might be doing something wrong, and he can even come there secretly to be doing all those things and they call them. It's very good. He's a good man. He's a very good man. Yeah, it's very good.
I don't think it's bad though, because at least sometimes it helps reveal some of the things that people are doing secretly, and it will help put people in shape. Like, because if he goes undercover to take people, and then it reveals what they are doing secretly, it will put people on their toes. So you are sometimes next time when you are doing something else, you be cautious that if you are not careful, someone might take you on. What he's doing is right though, but if you want to consider it in the details, you know, sometimes the way and manner which he gets the information, I think, is infringing on people's rights at times if you ask.
To try to use somebody to commit that kind of crime. See now, deceive somebody to bring him to commit crime. That is all good. See now, if you want to do investigation, you do it in the manner that genuine, but not the one that you lure him and then try to make him some ways and means of trying to catch him that way. You see, that's all good.
I don't think it's bad. He's just doing his job. So what he has to do, he has to do it. That's the best thing he can do for Ghana.
I agree partially because, yeah, you know how the system is going and someone will try duping you and all that. I think sometimes it's right if that happens. And there are times to he may be tricking others in order to come out with the truth. Yeah, that's also another side of it. So that's what I think.
Anas investigative works have captured many public officials said to have allegedly engaged in wrongdoing. Minister of State for Finance, Charles Edubuahin, was seen on video and was said to have taken some money on behalf of the Vice President. On June 2019, torture home captures Echoing Hill Village Orphanage, run by Baptist Pastor Lawrence Lamina, engaged in child abuse. One of the biggest, on May 18, was the number 12 scandal, which saw former Ghana Football Association boss Kwesi Nyanteche's kingdom brought down when he was seen on tape allegedly taking bribes. On December 2015, Nigeria's baby farmers saw Anas expose those behind Nigeria's baby trade. The piece saw couples desperate for babies and how some doctors offered them fake treatment in return for huge sums of money. On September 2015, Ghana, in the eyes of God, captured judges selling justice for goats and yams. Ghana's judiciary was brought to its lowest level in history. Many judges were removed with or without benefits. April 2014, Ghana's soul takers also showed how alleged corruption at the DVLA resulted in the death of many on the roads of Ghana. Ghana's sex mafia expose tells the story of Chinese girls trafficked into Ghana and how Anas went undercover to bust the ring and testified in court, leading to the prosecution of the traffickers. On November 2014, Anas teamed up with Al Jazeera Africa to investigate Nigeria's quack doctors who risk the lives of vulnerable people in Nigeria. On January 2010, Inside Ghana's Madhouse exposes Ghana's biggest psychiatric hospital human rights abuses. And the Tiger Eye Cocoa Smugglers expose on April 2010 saw how security men at Ghana's borders aided smuggling of cocoa. While the Soldier Bar investigation on September 2007 exposed some teenagers forced into prostitution at the Kwame Nkrumah Circle in Accra.
All right, welcome back. So I think enough basis has been established for us to start or to proceed our conversation this morning on Inside Pages. Now, I need to read this as quickly as possible because as far as the judgment is concerned, there's been a reaction from the Tiger PI, which is the investigative firm where Anas works. Now, Tiger IPI has a statement on the judgment. It says, statement on the judgment of Justice Eric Ma in the case of Anas Arimayao, Anas versus Kennedy Japan, suit number GJ 892/18. Now, it says, today, Wednesday, 15th March 2023, a High Court presided over by Eric Ma J dismissed a defamation action filed by Anas Arimayao, Anas of Tiger IPI in 2018 against Kennedy Japan. The entire judgment was read in open court. Now, the court established that Mr. Japan indeed defamed Anas, but in a bizarre twist concluded that the so-called documentary, Who Watches the Watchman, was an absolute justification, thereby absolving Mr. Japan of any liability. We find the decision of the court an unfortunate travesty of justice and very inimical to the administration of justice and fairness. If for nothing at all, Mr. Japan made an allegation of murder against Mr. Anas, there is absolutely nothing contained in the said documentary which alludes to the commission of murder or an allegation of the commission of murder by Mr. Anas. Thus, that documentary cannot provide any justification for an allegation of murder in the wildest imagination. Yet the judge conveniently ignored the obvious fact, and the fact that Mr. Anas is not a suspect for murder and is not under any investigations for murder. Number 4, this case traveled through the hands of 3 judges, with Justice Barr being the latest assigned to the case at the express instance of Kennedy Ejapon. Now, this is very important. I need you to listen to this because I've read some piece by Manasseh Azuri who thinks that something untoward has happened. In fact, I've also heard some lawyers who feel something untoward has happened there. And there are other lawyers who disagree and said it's fine. It's very okay. It's very regular. There's no point reading any meaning to it, but it's a subject of controversy. So listen, please listen to this. The case traveled through the hands of 3 judges, with Justice Barr being the latest assigned to the case at the express instance of Kennedy Japan. Throughout the trial, Mr. Japan displayed absolute disdain and disrespect of the court and the lawyers of Anas, but all attempts to cite him for contempt hit a dead end. We note that Mr. Japan attended court in the company of Mr. Kwesi Nyantakyi, who has been banned for 15 years from all football-related activities. Tiger IPI and our CEO, Anas Arimayao Anas, remain resolute in our fight against corruption in the Ghanaian society in service to God and country. So that's the reaction from Tiger IPI, which is the investigative firm whose CEO is Anas Arimayao Anas. Let me introduce my guest. Now, I have Mr. Kingsley. In fact, he's a private legal practitioner, Kingsley Amwakwa Bwedu. He's joined us here on Inside Pages. Good morning, sir. Thank you very much for joining us. Now, it's also interesting. There's actually one of the legal teams. I told you, a member of the legal team.
I was a member of the legal team.
A member of the legal team of Kennedy Ohene Ejapon. So he's the best person to tell us exactly why what he makes of the case and why, and all the criticisms that have been leveled against the ruling or the judgment. And also, the man who, for the first time, is visiting us, and he's actually supposed to be a friend of this station, but unfortunately, he's visiting us for the first time. I'm talking about the Honorable Abraham Amaliba, who is the head of legal affairs or director of legal affairs, NDC. A private legal practitioner as well. Good morning, sir. Thank you very much for joining us.
Good morning. Good morning.
Like we say, it's in Hausa Sandazwa.
This is not the first time I'm visiting you, but I'm visiting you for the first time ever since you moved into these premises.
That's true.
So let's put it clear.
That's how lawyers deal with specificity. So you're absolutely right.
Yeah.
Anyway, so let's do this. Let me also say that I have Dr. Rena Akomperega. Now, Dr. Rena Akomperega is also a private legal practitioner. He's got some very strong views on on this particular matter as well. Doc, what I'm going to do is that, Doc, I'm going to come back to you. I'll get a member of the legal team for Ken to put all of this in context, and then you can come in. But Doc, let me say good morning to you. Thank you very much for joining us.
Good morning, and it's a pleasure to join your show this morning.
Great. Awesome. So, Kisley Amwakwabu will have to leave us at some point. So, I think it's only fair that I get him to give us his side or where he stands as far as this is concerned. So, Doc, please hang on a minute. I'll come back to you. Okay. All right. So, Kisley, I'm sure you have heard all the reactions that have greeted this judgment. In fact, I've read one of them by Maxwell Pokwajimine, who we all know is one of the legal brains that we have in this country. Now, one of the concerns that he raises in that piece of article is that he gets the sense that not many people have taken their time to read the over 65 pages of that particular judgment. And so a lot of the commentary has been based on headlines. And so it's been very superficial, and it's been very surface, basically. Do you agree with them that having monitored public commentary and public reaction, you get the sense that not many people really understand what this case is about and why the judge made the kinds of decisions that he made? Do you agree with them?
Good morning to my Sin Central constituents, and good morning to everyone.
Okay.
I agree with him.
Okay.
I agree with him first because of the topic is considered as one of the law of torts.
Okay.
So it's a tort.
Right.
And not many people understand that.
Okay.
And
what's the law of tort? As in T-O-R-T.
T-O-R-T-S,
Okay.
law of torts.
Torts. Okay. S.
And so, yes.
What's the law of torts?
So the law of torts basically is a civil wrong done an individual.
Okay.
All right. And then the person has, so it's a civil wrong done an individual, that which does not arise under a contractual relationship.
Okay.
And so if I come and engage in a contract, then it will be a breach of that contract.
Okay.
That would have ramifications. And
Right.
you can sue for damages or specific performance and things like that.
Okay.
But if it's a tort, it is a fact that we live in a community of human beings.
Okay.
And so if, for instance, if there are ramps which are too high, then I can sue under tort if I drive over it and injure my car.
Okay.
Or if someone in my neighborhood makes excessive noise,
Right.
then I can sue on that. And if someone makes a comment, in this case, because the Constitution enshrines our freedom of speech.
Okay.
All right. And so if I make my freedom of speech, if I make my speech and it infringes on your person,
Right.
or on anything of yours, you have a right to sue.
Okay.
So that's where we find ourselves.
Okay.
And the Constitution is clear in Article 15
Right.
that there's a dignity of all persons and it's inviolable.
Okay.
All right. And so whatever I'm doing, I must make sure that it doesn't infringe on your right, basically. Then the Constitution also, in Article 18.2, talks about your right to your communications, which cannot be interfered with.
Okay.
So all these are rights which are inalienable, but they are guaranteed under the Constitution.
Right.
And again, the confusion arises from the fact of if you like, the value judgment placed on the activities of Anas Aramiao.
Okay.
But the judgment is in respect of whether or not he has been defamed.
Absolutely.
Except that because of the defense, because the defense was justification and fair comment.
Right.
And so then it would delve into whether or not the activities are right.
Mm-hmm.
Okay, so that even though we're looking at whether or not he's been defamed,
Yes.
at the back of our minds, it is replaced by whether Anas is a good person, whether his job he's been doing is good.
Okay.
And that generates a discussion. Then, just after the decision, the judgment came out, there was this weird, some of them had been converted into PDF version. And that's what everyone is reading.
Yes. That's what I have.
Precise, but this is a certified copy.
Well, what's the difference?
Okay, so when we have a certified copy, that is official copy. That's the one emanating from the court, and that's what we speak to.
Oh, okay.
So what you have is 66 pages. What we have here is 70 pages.
Okay.
All right. What you have has the names of some lawyers. There's about two of them. What you have here have all our names.
Okay.
Now, that's where you see my name and see
Yes.
all the other. So this is the official document which I made for. I have the soft copy I can forward to you.
Okay.
And not what is going around.
Right.
And so it may be the accurate representation, but just by the fact that it's even 66 when there are 70 pages, it cuts some doubt on
But in
that.
terms of substance, nothing changes that much.
As I said, because I know that is not the certified copy, I waited, went to court myself, got my clerk to get the certified copy, and that's what we speak to.
Okay.
So generally, it could be that someone was typing it. I don't know how it was procured.
Okay.
It could be that someone was typing it. It could be that a journalist was quickly typing out what was being read, or someone got a soft copy of it before it was. So we should be speaking to the certified copy.
Okay.
When those who report cases go to court, they'll get a certified copy and then report it, then be part of our Ghana law reports.
Okay.
Or if I'm supposed to adduce anything in court, this is what I have to tender in court.
Okay.
Add a certified true copy
Okay.
of that. Now, it is voluminous.
Okay.
And as my learned senior Opoku Ajiman said,
Yeah.
it's a good text for all students of thought.
Absolutely, yeah.
And I am also a lecturer, and I tend to set, I used to teach thought, but I've moved on to teach other things.
Okay.
I used to set, and I still set topical issues that's happening as an exam question, because he took his time, and it's a very fluid judgment. Some of the judgments are very condensed and technical, that if you are not a lawyer, you will read the first page and put it on one side.
True.
But this is fluid, and he took his time to explain what thought is.
Right.
And because he said the personalities, and he said it's a mammoth case.
Okay.
All right. And it has far reach. That's why we're talking about it. There are several cases that happen. We don't talk about it. But this, we have the cause to talk about it because of the personalities involved.
Absolutely. In fact, the judge himself mentions that.
Precisely.
Yeah.
Because of the personalities involved.
Right.
And the far-reaching effect of this. And so I think people are taking stands against it because they think it attacks journalism.
Absolutely.
And it attacks investigative journalism.
Journalism.
No, it doesn't. If anything, we'll all sit back after all the emotions are settled and we are very technically looking at it to see how do we still achieve the same thing Anas may have achieved, but do it the right way.
Okay. Okay.
They do it the right way.
I get it. I get it. So as far as you're concerned, why were you taken to court as the lawyer for the defendant? Why were you in court?
Okay. So I'm part of the legal team.
Yeah, part of the
There was
legal
an actual
team.
lawyer,
Right.
Ralph Kwame Japon, who was
Yeah.
a lead lawyer.
Right.
And I don't want to take a shine on that.
Right.
Yes, but as part of the legal team. Now, it is that comments were made
By your client?
by my client.
Yes.
Comments were made.
Yes.
And indeed, the judge took time to go through all that. And
30 of them, isn't it?
yes. And there are elements of defamation.
Right.
All right. 4 main elements. The first 3 went against my client. And I expected it to be so when I was seated in court, judgment was being read.
Okay.
Because whether or not a statement that can be interpreted as defamatory has been made, clearly.
Right.
If you say someone is corrupt, clearly you've defamed the person.
Right.
Because the definition of defamation is that making a comment about someone that lowers his estimation in the eyes of right-thinking men or right-thinking people. Now we have to be gender cautious. So
Yeah.
right-thinking people of the society.
Right.
That is the standard. So anything you say that reduces the estimation of that person in the eyes of right-thinking men of society is contemptuous.
Right.
Clearly.
Right.
Then there is whether it was said about the person.
Yes.
Of course, he mentioned his name, and everyone knows it. If I said, who watches The Watchman? All right, and showed that. And before then, he had said a lot of things about him. All right? And mentioned some other personalities that I don't want to mention their name because they are not here to defend themselves.
Absolutely.
All right? So, clearly, these two. And whether or not there was a publication is, I probably have an altercation with you or we exchange unpleasantries, and then I make sure a third person hears it. That's publication.
Yeah.
So was it published? Of course, you stood on his TV station and other media houses and said what he said.
Okay.
Does he have a defense? I think that's what the issue is.
Right.
Because he's saying it's fair comment and justification.
Right.
Now, we all know in law that he who alleges must prove. So right from the onset, that burden was on the plaintiff, being Anas and his lawyers. And it was established. They brought all the messages and the text and all that. It's established.
And
It's
brought the
there.
publications as well.
Precisely. And to make their job easy, the defendant said, yes, I said it.
He didn't disagree.
No, he didn't deny it.
Yeah.
He said, I said it.
Yes. But this is my reason for saying it.
I have a defense for saying what
Okay.
That is what it is.
Okay.
So if I was lawyers on the other side, I will be throwing everything I can against whatever defense, whatever thing you're saying is true and is a fair comment. That is what I'll be attacking.
Right.
I will not be jubilating on the first three elements which were resolved in my favor, because that means nothing.
Right.
It is because there are instances where we even exchange words in public,
Okay.
and the law is that if you insult each other in a heated argument, it doesn't amount to defamation.
Right.
Because you were insulting each other.
True.
All right? There was a case where a certain lawyer in the 70s was caught that he doesn't know anything about law and order, and he was sued, and that was the determination of the court.
Okay.
So there has to be a lot of work going into, because now the burden has shifted to the defendant.
Yeah.
He must bring evidence to show that indeed what he said was the truth.
Right.
And then he needed to alert the public, and that makes a fair comment. All right? And that is what he did by bringing the video clips. And I've watched it over and over. In fact, I do not want to be the one disseminating, distributing that video.
Okay.
Right? Because there's a lot more in it. All right?
Okay.
So once anyone who sees this will come to a conclusion of what the judge came to. Why? Because the judge is both, because in other jurisdictions you have a jury and then you have the judge. So he's concerned himself with the law. So the jury is going to come and say that this is true. Then he will say, if this is true, then these are the legal consequences. Okay. In Ghana, we have the jury of fact and jury of law being the judge.
Okay.
Except in certain cases that the law says for this, there must be a jury.
Okay.
All right. So if he's a jury of fact and jury of law, then he has a right to make a decision, a determination on the factual issues. It is true that he may have said some things which are orbital, and that is what is trending, because in Ghana we like trending issues.
Right.
So if he's saying it's not investigative journalism, but investigative terrorism, that's what will trend.
Right.
All right?
Right.
But there will be the factual basis for what he said.
Right.
The factual basis for what he said. In the video, you see a state attorney being compromised with $5,000. That alone seals or solidifies the position of the defendant.
Okay.
Because you are anti-corruption person, right? Just like the defendant also touts himself as anti-corruption
fighter.
Yes, you see. Then you are now going to corrupt someone. And that so that a case does not go well, does not see the just conclusion. And indeed, it did not see the just conclusion. These are issues. Okay. And then you are mentioning it is you, your own recording. It is not the recording of the defendant. It's your own recording that came into the hands of the defendant that he used against you.
Yes.
And then you challenge that it's not the authentic one. And that's all you said. You have to go further to prove the fact that it's not authentic by bringing because it's your recording. Yeah. So bring the original, let's just suppose, against what has been proffered in court. Then we see whether it is cut and paste, and all you said is it is not. But now, if the burden cannot be discharged by just making comments in court.
So it's not enough to say this tape is doctored, this tape is fake. You have a responsibility to provide the original tape.
Precisely, because we are in a court of law. In a court of law, evidence is what
the name of the game.
Exactly.
Okay.
And you are a lawyer, all right? And you have done this work. And the first, as I said, will be resolved. Even the third one, which is whether or not it was in reference to you, all right? When you came to court and the video was played, you said you are not in it. To begin with, you did not appear in court. You made someone come in your stead. When a matter is in personam, not in rem. In personam, as in it affects you. So you have to establish how it affects you.
But how do you know he wasn't in court? There were two surrogates in court. How do you know if one of them was not on us?
No. Someone represented him, because you cannot just come as a surrogate. You're talking about when the judges were being administratively where it was being administratively determined whether they should be removed or not.
Yes.
That is when there were three 3 Anases
Yes,
speaking at the
You
same
can call them
time
surrogates,
and
yeah.
of all the same height and whatnot. That's
Okay.
what we're talking about.
Right.
We're talking about this matter, this case.
So this one, there was a rep.
There was a plaintiff who represented him.
Okay. So
he's
Anas
a
himself was
plaintiff.
not there in person?
No.
Oh, I see.
Okay, so the matter about this normally is in persona.
Okay.
Now, anyone can make someone represent him in court.
It's normal.
You can't even force someone when he brings a matter to court.
Okay.
You can't even force him to give evidence himself.
Okay.
So it's normal.
Okay.
But it all adds up to how you defend or you make your case.
Okay.
All right?
Right.
Now, then the MP was always in court.
Okay.
Apart from a few instances when he had to travel.
Okay.
All right, out of the country. He's always in court. And he came and said, yes, I said this, and this is my justification.
Okay.
You need to do more because, as you said, this is of a mammoth proportions. It's going to, because those who read who are not lawyers, and I've heard a lot of commentary. Yes, I was listening to it on one of your sister stations, and you can tell that people are now speaking English about it, and it's not English. It is a legal text that has to be interpreted by lawyers.
Okay.
And people are now saying that it means Anas is finished. I don't think so.
Okay.
I don't think so.
Okay.
It is a defamation suit he brought that he lost.
Okay.
That he has a right to appeal.
Okay.
He has to, if he wants.
In fact, he's hinted that he would appeal against the case.
He's at liberty
Right.
to do that.
But a few issues here, and these are the issues that have come up for criticisms. Now, the first one, and I'm going to read something. I'm sure you've seen the Manasseh Azure's write-up.
Yes.
What he calls the twist and turns of the event, and I get the sense that he's trying to suggest that there's something fishy or he smells a rat. Now, what is Manasseh saying? And it's been proven to be a matter of fact. Now, he says that. So Anas Arimeyaw Anas sued Kennedy Japan for defamation in 2018. Justice Daniel Mensah, the Domahine, was the judge handling the case. Okay. Now, in the latter part of 2020, Justice Daniel Mensah was then transferred to Tema. A Court of Appeal judge, Justice Eric Barr, was appointed interim judge to handle the case pending the appointment of a substantive judge. In June 2021, a substantive judge was appointed to continue the case. Now, we're told she's one Justice Gifty Ejay Ado, the judge who overturned the General Legal Counsel's suspension of Francis Xavier Sosu from practicing as a lawyer. She was then put there as a substantive judge. Now, on December 1, 2021, Anas and his team discovered in court that the substantive judge had been taken off the case and the interim judge had returned. They had no idea what had happened. They were given an explanation by the judge when it came up in court later. So he was expected to have been written to and informed that this is the new judge, or this is the judge that's going to be sitting on the case substantively. But he said he wasn't, they claimed they were not told. Now, on the blind side of Anas and his legal team, Kennedy Ejapon had written to the Chief Justice to request that an interim judge should return to continue the case. And that's the judge who ruled on this matter.
Eric Byers.
Yes. Now, he continues to say, the reason Kennedy Pond and his lawyers gave was that the interim judge had observed the demeanor of the parties and is abreast with details of the case, including its nature and scope. So the substantive judge, Kennedy Pond said, would take time to familiarize herself with the case, and that's Judge Gifty. So she also does not have the benefit of the demeanor of the witnesses so far. Now, a week after receiving Kennedy Pond's letter, Chief Justice Enini Abua directed Justice Eric Barr to go back and continue the case as Kennedy Pond requested in the letter to the Chief Justice, and he attaches, the letter. Okay. Now, when Anas and his legal team expressed their conclusions about seeing the interim judge in court, Justice Eric Barr said he has been directed by the Chief Justice to continue the case. He adds that Anas and his team were expected to have been served with Kennedy Ejipon's petition and the Chief Justice directive, but that was not done. And I'm reading all of this to you for you to tell me whether you think that from where you said something untoward happened. And that's the same of the Honorable Abraham Amaliba. And he considers, I'm not a lawyer, but I'm wondering whether it is normal for one party in a case to write to the Chief Justice to suggest a judge without the knowledge of the other party and have that wish granted. So that's what all of this comes down to.
Okay.
And the fact that when there was even a change in selecting a substantive judge, one of the parties to the case was not informed, and whether it is normal practice or it is not normal practice for the party to be informed that, okay, you're coming to court, know that this is your judge, for whatever reason, you have to be informed. So those are the two questions that I'd want you to address for me, which has come up as one of the criticisms in this. There's also a third criticism. The other criticism is this, that the tape in question, which is the Who Watches the Watchman, where Anas is heard about, saying about some $100,000 from Muhammad Batunde and so on and so forth. Whether that tape in itself is comprehensive or is sufficient enough to vitiate or to clear all the allegations that Anas, or that all the allegations that, Anas is making against Kenny Japan. That, look, you have defamed me, I'm suing you. And the judge says, so there's a tape. And that tape makes nonsense of everything that Ken Japan has said. So Ken Japan is innocent. Whether that tape is enough. Because there's he was actually accused of murdering a Chinese, and so on and so forth. Why didn't the judge look at all of this? Why did the judge just focus on just this one tape, based on which he decided to let go of... so those are the three questions before I bring in...
So to begin with, let me begin with...
The first one.
No, the tape.
The third one.
Tape, yes,
okay, right. Which is the tape in question?
There are KUE 1 to 4. Okay. So it's not just the tape.
Right.
KUE 2 was even very, very important. So when he was giving his judgments, he reserved that to the last.
Okay.
KUE 2 is the fact that the case that Anas is seen on the video clip compromising as his attorney did not conclude.
Right.
And the judge had to strike it out for want of prosecution.
Yes. That's also a fact.
That is what, because remember the test is, what would the right-thinking man think when he hears this or sees this? That's the test. The test is not whether Anas is a good investigator. That's not the issue.
Okay.
So even though we have to go into that to come to this conclusion, all right, that was not what was before the court. Primarily, primarily is that what would a right-thinking man in society, what would be his view when he thinks of this?
Okay.
All right.
But isn't that anecdotal?
Sorry?
Isn't that anecdotal?
It is not, because the definition of defamation is that bringing the estimation of someone to disrepute or lowering it to the estimation of the right thinking. There's law on this that someone was accused of being a crook, and it was said amongst, even like crooks.
Okay.
And the decision was that no, but you said it amongst crooks, and so that you have not been defamed because these are not right-thinking men of society. All right. So coming back to the issue of whether or not he's been murdered, he said, you called me a murderer, I also called you a murderer. You said, I've murdered Ahmed Swale. I'm saying you also, because you are saying, I put his picture, and therefore, I'm also saying that because of your expose, that is why this person, all right? And indeed.
But how is that a defense?
Indeed. Sorry?
How is that a defense?
Yes,
how is that defense to say that because I insulted you, also insulted me? How is that a defense in defamation?
Well, it's
not a defense.
No, but that's not what he said. Listen, the judge is saying that you saying he's a murderer, in a right-thinking man of society, they don't believe. They did not think it is so, because the right persons have been tried, and everyone knows that.
So now we can interrogate the judgments, the ruling of the judge.
Precisely on that. Precisely,
and that's what you say. Not to say that. Wait. Then you do insulted him.
No, that is part of it. That's not conclusive.
No,
that's not conclusive. That's not part of it. And the judge did not say that is the reason why I have ruled, I have resolved this in favor of the defendant. He said that everyone knows that because you are saying that your estimation has been reduced in the eyes of right-thinking men, and that's a standard.
Okay.
If that's a standard, then this is of no moment.
All right.
All right. Now, the second one was, if you may remind me.
Well, the second one has to do with the So I asked about whether the tape was substantive enough.
There's
Yeah.
frequent changing of judges.
And the frequent
that's
changes
the
of
one.
judges.
I'll address
that's
that
one,
last,
yes.
but
And the frequent changes of judges, and the fact that Anas's team were not informed about the change of the judge.
That's the same about the change of You said something else.
No, okay,
I want to address the change
so-
of judge
so- yes,
as a
so-
last because my time is almost
Yeah,
up.
so change of judges, that's
Okay.
one.
Okay.
And then two, whether the tape, I asked about whether one tape was enough,
Was enough.
to clear,
And
and
I said
you've addressed that.
Exactly.
So let's come back. So let's now come back to the issue of
So
change of judges.
he said interim judge, and I don't know whether we have an interim judge. The fact is that a judge is sent to a court, and all matters are brought before him. All right. If the judge thinks that he will not be on this case at trial, he will do the preliminary issues, the motions, pleadings, and whatnot. He may not even do the CMC. All right, CMC is a case management conference because that is substantive to the trial itself. But once the judge has done that, the judge has commenced a matter, then the judges are looking at the pieces of evidence and also the composure of the parties.
Right.
All right,
Okay.
because you can be lying through your teeth,
Okay.
and the judge will know. All right?
Okay.
Even though we say there's no art in finding mind's construction in their face, it is part of their training
Okay.
to look at your composure and everything.
Okay.
And so it is legitimate for our side to pray to the court, to the chief judge, because only the chief justice decides which judge sits on a particular case or in a particular courtroom. And so if you want a judge changed, you would have to petition or bring a case of bias against him. Now, what Anas said, I'm glad he ended that he's not a lawyer because he is opening a door of bias and it's not good at all for him because he's not even part of this case. And he's also an investigative journalist and he's done a good job in this country.
But is it true Ken actually requested for a particular judge?
Precisely. You have to pray that because he's observed our composure in court and all that, let him continue.
And it's normal practice.
This is so. Now, the Chief Justice can agree or grant that, or precisely. So and then, of course, the judge asks whether you have been served. It is not us who serve them. It goes to the system. All right? And if at that stage they realize that they don't want it to happen, then they can also counter-petition or bring a charge of bias. We all know what the issues are when you talk about bias in the court of Ghana. We all know. Familiar relationship, pecuniary interest, proprietary interest. Salah and Attorney General. Both of us are lecturers. We use this to teach us law students. We know this cannot be founded. All right? So as for the administrative issue of them not being served, when it is the court system that was served, indeed, when they go to know about it, they could also do, yes, I think the second one was contempt. You were saying that he's acted in contempt, his attitude.
Yes.
And I want to address that
because
it's very important.
Yes, because he said yes.
This, and I'm advising Manasseh that he shouldn't push this because he's borderline trying to impugn the integrity and legal sagacity of his lordship Eric Baje. No one has been able to do that. I use his books for cross-examination. I learn because he's a good writer. I mean, you can see the way he's written. He appeals to all the different sectors of society. And when you read it, you may need maybe Black's Law Dictionary for interpretation or just ask around or something of that sort. But it's so fluid, and that's how that judge is. And we all like him for that. As several judgments you read, I am not even in a case, I happen to be in a court. I'll make an application for a copy of that judgment because there's a lot, that's how this judge is, including several other judges that we know. So he's a very tight, narrow line. He shouldn't. And today I listened to him on another station, and he's not addressing the salient issues. He's abandoned that. He's not talking about the salient issues. As to the issue of investigative journalism, it cannot die in Ghana. And when I was entering, you were playing the president's comment.
Yes. About using the Anas principle.
He said, exactly. And the president will not have meant that do entrapment. He said, when he went further to talk about undercover, and undercover is used everywhere. In fact, there was a case in the 20s, I think it was 1927, when a prominent chief in the Achim area was murdered. All right? and we couldn't even find the body. And in criminal law, in murder, if you can't find the body, it's a big issue. Because now, how do you tell me the person is dead? You have to prove that.
Okay.
If you don't have the body, you have a long way to go to prove the person is dead.
Okay.
Ghana police, and I dove my heart out to them.
Right.
They dispatched an investigative general, an undercover person. You know what he did? Then he went to the town before the place where it had happened, and then put on some old clothes and started dribbling. He appeared in the township as a madman.
Okay.
Sat there under the scorch of the sun and the elements of the weather and all that for 3 long months. And so discussions were going on around him. Go, this madman. That's undercover. And when he walked back to the next town, Chain sat in the car. After about more than 3 months, sitting on the side of the road, sleeping there, doing it. That is Ghana police for you. And I don't know so undercover always happens.
Right.
The issue is, should you entrap? Entrapment is, and I can read here, there are several cases on that. When you now induce, it's like I come here, I know certain things are happening, but I've not been able to catch it. So now I go and now induce that. You know that you are also culpable when you give a bribe, including the person who also
like
received
you're
the bribe.
setting the person up.
Precisely. All right? But you can also follow someone through people in other jurisdictions.
Yes.
People have married because it was their job to marry the person. People have had amorous relations with because it was their job. So that the objective to the person was, I need to see him do that. People have gone undercover, done several things in the cocaine business, so
you're saying that
must be
entrapment
protected.
in itself is not bad. It depends on how it is used.
No, undercover is not bad.
Undercover
Entrapment
is
is
a
bad.
problem.
Yes.
No, but
that is why.
But have you heard the counter argument? And the counter argument being that when you give meat to a vegetarian, they will not eat.
Yes. So should you now, and you still want, so
when
you
give
want
meat to a vegetarian,
you will
they
eat
will not
exactly.
eat.
In
They will
my
not
language, we say incredro,
Yes. Yes.
right. So now, is it that you really want to kill this ekra,
Okay.
or you want to make sure he by all means go in for what you have heard that you don't have any evidence for? Okay. Then you do what you do. Then you come in and trap him.
Okay.
And it is so clear, everyone in all the jurisdictions. You cannot, that's why we talk about compromised or tainted evidence.
Finally, before you take leave of us, do you get the same, well, I'm maybe asking the wrong person, but again, some people have made a certain observation that it appears the judge was more focused on Anas and his method of doing things than the pronouncements that have been made by Kennedy Ejapon. So it's almost as if it creates a certain impression as if the judge had a problem with Anas. So now I get them. It's time for me to fix this guy because he's been a. No, I'm saying that that's how it
is because
appears.
of the commentary going. And you see, in Ghana nowadays, it's good, freedom of speech, but people should take their time, read the case, analyze it before they come out, because then people are now speaking English,
All right.
and then they're not talking law. It's a different thing.
Okay.
Right. Listen, he already resolved the issue of whether or not what Kennedy Ejapon said is capable of defaming Anas.
Yes.
And whether it has. Resolve that. That's
Yes.
why in Manasseh's write-up, he even said that. Now,
But that's not what Anas is in court.
No. But having arrived at that,
Yes.
is there a defense, as we said?
Yes.
Is he justifying?
Yes.
And for being the jury of fact,
Yes.
he needs to go into that.
Okay.
I need to hand.
I know it's unfortunate you have to take leave of us because I have
bring
quite
my friends here.
because I have quite a number of ideally I should have had Honorable Amaliba.
That's why I was saying you should go first.
And exactly, but
and
you
even
have to
Reina
leave,
is
so.
also my very good friend. We're all in Aberdeen.
Oh, Reina. Oh, I see.
Aberdeen to do the oil and gas.
Oh, that's interesting.
Yeah, together.
So would you want to grant us another 15 minutes? That's fine. You can do that. You can do that. All right. So let me, Dr. Reina would have to take leave of us at some point. So, yes. So, Kinsley, thank you so very much for your time.
You're welcome.
And have a good day.
You're welcome.
And now, Dr. Reina Kumperega would also have to leave at some point. So let me also finish. So I'm going to end the whole show with Honorable Amaliba. Would have all the time to discuss this issue so that he walk us through his knowledge of what he knows about this matter. Now, Doc, thank you so very much. And I'm happy that you've been able to exercise patience and, stayed with us throughout. Doc, are you with us, sir? Hello?
You're on mute.
I think you're on mute. If you can unmute, I'll be very happy, sir. Yeah, Doc, please unmute so that we can proceed with the conversation.
Yeah, Moro.
Yes.
Yes, I've rejoined the link.
Yes.
I'm with you.
I can hear you now.
Right.
So before I delve into specifics, what would you say are your preliminary comments, having studied the judgment or the decision by the judge? And of course, and then we can get into some specifics. So what do you make of the judgment so far?
Thank you, Moro, and good morning to all the viewers and listeners to your program. Now, so that this doesn't escape me, before I do my preliminary comment, I like to take a historical view of this matter.
Right.
And what is the historical view? The historical view is that about 7 years ago, this country had opportunity to make the pronouncements, conclusive pronouncements that has been made by the High Court. And in this case, it was at the Supreme Court. You remember Justice Derry took issue with a petition that was brought forth for the removal of justices, including Justice Derry. Now, his beef was that this particular modus operandi by Tiger Eye was unconstitutional to the extent that it contravened Article 18.2 of the Constitution. And for purposes of your viewers, Article 18.2 protects the privacy of citizens, protects the right and privacy of citizens, their residence and all of that. That was an issue before the Supreme Court. Now, the Supreme Court pronounced, and note, the Supreme Court pronounced, that is 2016 thereabout, pronounced that indeed there was constitutional contravention by Anas Anas on Justice Derry to the extent that his privacy was intruded by the methods, the very method that he used. But the court didn't go as far as granting constitutional reliefs to Justice Derry, who's a citizen of this country. It rather referred him to go on the route of seeking private reliefs. If you go and look at the reading very well, that it could seek reliefs in the nature of defamation, it could seek reliefs in private rights, as it is. But you know that when a matter is unconstitutional, anything that is built on it is also unconstitutional. It collapses. You cannot build a bridge on something that the foundation does not exist. So it is curious that 7 years on, a high court has had opportunity to comment on the nature and the mode of operation. So if you like, the methodology that is employed by Anas and in discovering information or finding issues against persons. So I think that we missed that opportunity in 2016, 7 years ago, to the extent that those justices, especially Justice Derry, because once the court found as a matter of law that Article 18 was actually contravened by the defendant, that's Tiger Eye, then it presupposed that everything, including the petition itself, should have collapsed. I just want to bring this because, see, we're building a country and we're building institutions. In the fight against corruption, you do not want to shoot down the stakeholders, especially the media and other institutions, including the courts, the judiciary. All of us are, and the legal professions and commentary, all of us are part of the system to build our institutions. But we must be consistent in pronouncing the principles of law that apply. And this consistency must apply to every citizen. And this is the first comment that I would like to make.
But
now,
Doc,
secondly,
Doc, staying on that particular comment that you're talking about, in the Justice Derry case that you're talking about, where the court actually upheld Anas's methodology of eliciting information, that's, and you can correct me if I'm wrong, didn't have to do with what you do before the fact and not after the fact, because here, in this particular case, the judge is talking about what you do with the evidence or the material that you collect. And the accusation that when Anas collects the materials, he then goes to trade, based on what the ruling said, he trades with the materials that he collects. Said, I have something on you. If you have money, bring. So I don't disclose it. If you don't have money, I'm going to go ahead and disclose it. So I don't know whether the two scenarios are the same. Because this one, what I understand, it's after the fact, which is after he's collected the whatever information or data he has, what he does with them. And that's why he says he's an investigative terrorist and not an investigative journalist. I don't know whether you get the import of my question.
I do get you, Mero, and I agree that to that extent, the two cases, the two scenarios are not the same at all.
Okay.
Because that Tiger Eye case, the matter was the method.
Yes.
And the question of the issue was whether or not, even in commencing the investigation, in going to the person's house uninvited, in seeking to include or engage or coerce, or if you like, engage the person to say or divulge information or all that without his permission. I think the issue was whether that contravened Article 18. And so it was a privacy matter. It had nothing to do with then what do you do with the information?
Okay.
Having collected the information through whatever means. And the court did not okay the method at all. Indeed, it found out that, it made a finding that that was actually unconstitutional. That's what the court said. It was unconstitutional. Okay, but there were no issues of corruption as it is present in this case. The court said it was unconstitutional. However, and the court referred to the 2012 case where Justice Atoba said that, look, it is not every unconstitutional act that should be declared void and null and void. And that the fact that it was unconstitutional does not mean that they could not use the material that they had in their formation for purposes of pursuing the petition to remove the justices at the time. And so there's a clear difference and a nuance, and I agree that there's a difference. But I needed to go back because to the extent that the methodology was an issue, whether or not it contravened the Constitution. If a matter contravenes the Constitution, that's a grave matter because the Constitution protects rights of citizens, including privacy. And I needed to bring that on board so that we can have a more comprehensive, because this would happen again. It's not the first time, it won't be the last time.
Right, that's fine. So please carry on, because you were telling me about your preliminary thoughts about the judgment.
Yeah, my preliminary thought, I want to take two comments that were made by my friend. Kingsley is a very good friend of mine.
Yeah, he tells me.
UK together studying. Yeah, he's a very good friend of mine. Now, there are two comments that he made. Number one, that on burden of proof, and whose duty of between the defendant and the plaintiff, who are the burden of proof. Now, this matter, and in the ordinary sense or in the ordinary cases that we have in court, it is always the plaintiff that bears the burden of proof. Okay, so that if you go and allege that you have a contract with someone and the contract sum of this, and that you have executed the contract and this is the amount you're supposed to pay, and all of that, you, the plaintiff making this allegation, should bring material facts, okay, by way of evidence, documentary, witnesses, whatever you have, to prove your case. That is ordinarily the case. But this was quite different. And indeed, the court found out the three levels of analysis of defamation, and you know defamation, the three levels of analysis. Kingsley alluded to the fact that the judge said, look, those comments inherently or by their nature and form had a propensity to occasion defamation against a person. The court was clear on that. Now, secondly, the court established that those comments were indeed made on the person of Anas Amir and Anas. At that point in time, the burden shifted to the defendant because this is a civil trial. It's not a criminal trial. It's a civil trial. It's about the preponderance of probabilities, the believability of the evidence or the witnesses that will be put by the respective parties. So that case meant that the defendant now had to prove that indeed what he said was true. So at that point, the burden was on the defendant to say, what I have said is true, because then he was mounting his defense. Did the defendant successfully mount the defense that what Kennedy Pond said about about
Anas.
Anas are true? Did he do that? And there are questions about admissibility of evidence. If you read the judges, I think that if there's any prospect of appeal at all, the lawyers and Anas might look at whether some evidence were admissible at all. And even if they were admissible, what weight could the court put on those evidence, being the fact that, look, these were not the originators of those documents. They were not the originators of the video. And if you read the judgment, you notice that at some point the defendant himself alluded that he could not speak to the matter because they were not the originators of the evidence.
Okay.
So these are matters that can go on appeal, and they've indicated that they will appeal. Now, secondly, and I've read somewhere, Maxwell, my lecturer at law school, and I've just listened to, Opojaman. I've listened to them make a very dangerous statement, which is that once you commence a defamatory matter, then your entire life is under scrutiny. That is not true. The reputation of a person defamed is in respect and within the context of the matters and facts in issue. Let me say this using practical examples. If you were to allege that I am a foul thief in Zoko Market, and that, look, I am notorious for it, the fact of the notoriety of me being a foul thief in Zoko Market does not mean that you can use that evidence to prove that I am a murderer.
Okay.
That has to be made very clear. So his entire reputation was not on trial at all. The reputation was on trial in respect of the specific allegations that were made against him. First, is he a murderer? That question had to be answered. Then, if it is true that he's a murderer, then the defendant would have discharged his burden of persuasion. What we call, under the Evidence Act, we call it burden of persuasion. That he has discharged that responsibility. And the burden of persuasion means that once you have produced evidence and enough evidence to discharge that burden, then there will be a ruling in favor of you, or that you avoid a ruling against you. I am not quite sure that we can put in a plethora of all evidence, whether the person is a drug addict, whether the person is a womanizer, whether the person is a rapist, whether the person is a thief, are irrelevant to the particular issue of whether or not he has murdered somebody. So it is not everything that he has done which is wrong or morally reprehensible that we have to go into and determine whether, it is not whether he's a bad person or a good person. It is whether the specific allegations that were made by Kennedy Pong are true. And that burden of establishing that they were true laid on the defendant as long as the court came to determination that they were defamatory and that they were referable to Anas. And that has to be made very clear. I don't know if you're full.
I follow your argument. I'm going to come back in studio. Yes. Doc, please hang on a minute. I'm going to come back to studio and then also pick the thoughts of Honorable Abraham Amaliba on this particular issue. Now, I don't know where you stand on this particular matter. There are those who feel that this judgment is a miscarriage of justice, as in a travesty of justice. Some say it's been fair to the facts. In fact, when you read Maxwell Opoku-Agyeman's piece, he thinks that it's fair and that you have to read the entire judgment back to back or cover to cover to be able to appreciate it. Where do you stand on this matter?
For me, the judgment delivered by the judge, the comments he made, and the matters before him are in variance.
How?
So, for instance, Anas was not under criminal trial. It's a civil matter. So for the judge to also commit what I would term as judicial defamation, hiding behind the fact that he's a judge so he cannot be held accountable, and describing Anas as investigative terrorist, that's also defamatory.
Really?
It is. But just that, this judge, is clothed with some, they call it protection. He's protected.
Judicial protection.
Else, that is also defamatory for Anas.
So sorry about this. Sorry.
There are.
Can Anas, for instance, take him on?
No, he can't because of that.
Okay.
To structure my arguments well, we need to look at the obiter dictum of the judge and then the reasoning of the judge.
Which is ratio
descending die.
Yes.
For the ratio, Anas can deal with those matters on appeal. But the obiter, one of it is what I'm talking about, describing him as an investigative terrorist. The judge went overboard on those matters. He didn't need to do that. And that's where your question is relevant, that whether or not what happened in court was not like Anas standing trial and not Anas bringing a defamatory matter.
Yes, I was asking Kingsley.
He asked Kingsley.
Yes.
You see, the judge went overboard on those matters. Then also, I have a problem with how fair comment, justification can be used to wipe away all the 30 comments that was alleged to have been made by Ken.
Yes, I asked the same question too.
Now, if you read the judgment on the issue of murder, where he accused Anas of murder, and Kingsley alluded to it here, Kennedy Ajapong did not deny. He said those words of Anas.
Yes.
Now listen to the judge in dismissing that claim by Anas. The court said the hypothetical reader would have read about the notorious case involving the murder of former member of parliament and would be aware of the trial of suspects which excludes the plaintiff. So, in the judge's mind, once Sexy Dondong, the accused person, is standing trial, and Anas is not standing trial together with Sexy Dondong, then the reasonable bystander will not believe this comment. How is this possible? Because we have what is called organized crime, which is done by so many people. So you might have caught the first person or one person. It's possible Anas is the second person. And don't forget, this same man, the guy standing trial, has constantly been mentioning names whilst in court. Or in
And we're talking about Sexy Dondong.
Sexy Dondong.
Yes.
So this, once Anas, and he alluded to it, Dr. Reina alluded to it, once the defendant, Kennedy Ajapong, could not justify that Anas was a murderer and has murdered somebody, I think this shouldn't have gone in favor of Kennedy. He should have proven it. It is very clear. So, and you read the judgment, you realize that the judge focused so much on a video, isn't it?
Yes, one particular video.
Exactly. The question I want
involving one Babatunde.
The question I want to ask is, in that video, was the issue of Anas being a murderer addressed in that video?
Not at all.
Not at all.
Yeah.
So it is true that this judgment will go a long way to damage the reputation of Anas as an investigative journalist internationally known. And the earlier he takes steps to set some of these things aside, the better for him. Else, this will be the beginning of the end of his profession in the investigative journalism that he does.
Do you have an issue with I don't know what you make of this Manasseh's, what they call the twist and turns, the change of judges here and there, and how Kennedy Ajapong specifically requested for a particular judge to sit on the matter, and how the other parties were not written to be informed that there's a new judge or there's a new king on the block, and how at some point, Justice Eric Barr did not assist or that did not help in citing Kennedy Ajapong for contempt. Kennedy Ajapong had treated the court with disrespect, as has been put out there. What do you make of all of this?
Ordinarily, this shouldn't have raised eyebrows because it's a normal thing in court where judges go on transfer. We have judges appointed to, what do they call it? Normally, when a new judge comes, he may not be the one to continue with the case because he has other duties somewhere. So relieving duties. So a judge may come on relieving duties. Then subsequently, a substantive judge will take over the court. I've had cases in that way. But when you look, and the judge alluded to that too, when you look at the two personalities and you look at the case involved, where this matter was before a certain judge, whether you like it or not, that judge has a certain reputation. He's transferred. Then you ask the question, why is he transferred? Is there a general transfer or it's about him? These are questions that people ask. Okay, he goes. Then a relieving judge comes. A substantive judge also comes to take over the court. Then one of the parties then writes to the chief judge and says that, let the other judge come. The reason being what? Demeanor. Tell me, in the judgment, did you see the judge making reference to the demeanor of the witnesses? So it was not an issue. Indeed, the substantive judge could have taken over once the records of proceedings were typed and all parties read it and agree that it's a true reflection of what took place under the previous judge. It could go on. This issue of a demeanor is a ruse because today we are wiser. Today we are wiser because today in the judgment, this judge has not made reference to the demeanor of the witnesses. So for me, it's a ruse. So it will fuel that perception. But it is within the right of the Chief Justice to transfer and then also appoint judges to take over cases. But you cannot also stop people from thinking the way they want to think.
Sorry about that. Sorry about that, folks. Now, I'm saying you and I are in court, and there's a particular judge who's sitting on the case. The judge has been transferred. An interim one was brought. The interim one goes, and the substantive one is brought on board. Can I write to the Chief Justice based on my own reasoning? And my reasoning is that I have observed the demeanor of this particular judge, and I believe that the judge is in tune with what is happening. So please bring back this judge. Does it lie within my right to decide or to request from the Chief Justice that he or she appoints a particular judge to sit on our case? Is it normal practice?
It is within your right to request that a case be taken away from a particular judge, but
Yes.
it's not within your right to then pinpoint which judge you want.
Yes, so that's what has happened in this case.
Uh-huh.
Where Ken says,
Yes.
it looks as if it appears to me, Ken's lawyer says, Eric Ban appears to be on top of the issue.
Yes.
So keep him there.
So by pinpointing to a particular judge,
Yes.
they had to justify why they are pinpointing.
Yes.
And they did their justification by talking about the demeanor
Yes.
and saying that this particular judge has seen the witnesses, he knows their demeanor, and all those things. Is that an overriding, consideration for one to be pinpointing that I want this particular judge to be on my case?
From
I
what
say
you
no.
said, is it?
I say no.
Okay.
But it is within the right of any party to a case, whether based on bias, and I've done that before, but I didn't succeed in my Asen North case, where I said that, look, this judge made comments which are injurious to my client. I want him to recuse himself. You remember that?
Yes.
He didn't recuse, and I decided to recuse myself because I didn't see that I'll get justice. So it is within your right to request that, particularly where you think the judge is biased, not only think, but you support it with evidence, to request that this case be taken away from that person. But it is not within your right to then pinpoint a particular judge that you want. That, I think, is wrong.
Dr. Reina Akomperega, do you also agree with those who feel that the judge overreached or engaged in judicial overreach? He went overboard with the kinds of comments that he made about Anas Arimaya, Anas. Never mind the fact that it is it's an what you call an actor dictum. That there's a word you use. Obiter dicta. Whether it was obiter dicta or ratio, whatever, it doesn't matter.
Now, thank you for your question. I want to respond to this and tie it into the possibility of bias. Just to take it from where my senior Amalwa left off. The judge has the Chief Justice is the head of the judiciary, and he has the power to empanel justices. Okay, he has the power to empanel justices. He has the power to administer and supervise, the affairs of the judiciary. And one of the powers that you can find about the Chief Justice. So to even transfer cases from one court to a different court, and from one judge or magistrate to a different judge or magistrate, that power exercisable by the Chief Justice seems to be unfettered. In fact, in Kunya here versus Archer, which was a case that was decided, it was decided that unless you can establish reasons of bias in seeking to change a particular judge.
Okay, so Dr. Rayner, I beg you, would like to take you off for a minute. We need to sort something out quickly and briefly. We'll bring you back. But so we'll get Dr. Rayner Akomberega back for him to continue from where he left off. Now, I was asking him about the issue of, never mind whether they, okay, you mentioned that it was actually an overreach. You thought it was, he went overboard. Yeah. And we've heard Anas say, he would appeal against the matter. From where you sit, is this something that Anas can he make any headway if he intends to appeal against this matter? Does he have a case?
You appeal based on certain grounds.
Okay.
Probably there's an error on the face of the record. There's an error committed by the judge, or that the judge did not take into consideration certain evidence, pieces of evidence available to him whilst in court. So it is left to the lawyers of Anas, and I have heard them hint, you read
they
a
will
piece,
appeal,
that they would appeal against this judgment, particularly so when you look at the issue of the alleged calling Anas a murderer. And I have indicated that it is not appropriate for the judge to come to a conclusion that because to him, a hypothetical reader of those comments would know that Sexy Dondon, or the accused person, the one who has been arrested, is standing trial, then it translates to mean that Anas did not commit that offense.
Right.
That statement by the judge is so wrong, in my view, that this is one area that Anas's lawyers can appeal against. Because one, Canada Japan actually confirmed that he made those statements. Two, he did not provide any defense for those statements. And when you read the judgment, in the written addresses of Anas's lawyers, they were entreating the judge to give judgment in their favor in respect of that particular statement, because it was non-contested. That statement that Anas is a murderer, and yet he couldn't provide a defense. According to the lawyers of Anas, that wasn't contested by the Japan. And since he could not provide any defense, it was, for me, inappropriate for the judge to come to the conclusion that any reasonable bystander reading this would come to a conclusion that Anas is not a murderer. And I have indicated also that because this particular case is even still ongoing, because they've not convicted the guy, we have seen instances where even wrong persons have been put before trial. Who knows whether the right person is the Anas and the wrong person is the one who is standing trial? And so it is not as clear as the judge wants us to believe that because Sexy Dondon is before the court and is standing trial, Anas should not feel hurt or should not feel that his reputation has been damaged by the comments. No, it doesn't work that way, because Anas could be the one who actually did it, but is walking freely, whilst the man who is standing trial could be the one who didn't do it. And I'm giving examples where after 10 years, when people have been put behind bars, we realize that they are not the ones who committed the offense. So this will not exonerate Kenya Japan at all.
Two quick questions. I don't want to keep doing this, but the two quick questions. When Anna realized that there was a new judge, okay, who was supposed to be adjudicating over this matter, and the judge came on the request of the defendant, and that's Kennedy Japan. Ken says, I want this judge to sit on the case, and the judge agrees and grants him that wish. Should Anas, for instance, have, because you said that it is well within the right of
the Chief Justice,
not the Chief Justice, but it's right within a party to a suit, to, for instance, raise issues about the potential of bias based on whatever reasons they have. Should Anas, for instance, have done that when Justice Eric Barr was then made the substantive judge that, look, based on the sequence of events or the chronology of events, I am not comfortable with this judge sitting on this matter, and so I want him changed. Should Anas have that? Because what I gather, and from what Manasseh has written, is that Anas and his legal team had granted the Chief Justice the benefit of the doubt, and that's why they had allowed Justice Eric Barr to sit on the matter or to adjudicate on the matter. If you were their lawyer, because I'm told there's also the politics of law, you know, would you have advised Anas that, look, I'm not comfortable with this arrangement, and so let's write to the Chief Justice asking that we also don't want Eric Barr to sit on the matter. And I'm not saying all of this because we're saying Eric Barr has any bias or anything. I'm just, you know, we're just thinking aloud. Should Anas and his legal team have done that?
You are only wiser when the events play out.
Right.
At that point, where Eric Barr was brought back,
okay,
any lawyer, particularly knowing that it was at the request of the other side.
Okay, Lawyer Maliba, please just hold on a second. And it's a question I'd really want you to respond to or answer, which is whether it should have written for him to be changed. Dr. Reina Komberger is back on. Doc, it's good to have you. It's good to have you back.
Yes, can you hear me?
Yes, I can hear you.
Good, I'm back.
So my question to you was whether indeed there was an overreach and whether the judge had gone overboard with the comment he made about Anas.
And that's why I was seeking to look at those comments. Of course, those comments were not what in law we call the ratio. Okay, the ratio is the substance of the ruling.
Right.
Those comments were obiter dictum. Obiter dictum means that, okay, by the way, okay, so if you are saying something substantively, then say, okay, by the way, this, and that.
Oh, is
now,
it the same as, sorry, Doc, is it the same as create, loot, and share? Would you also consider that as obiter dictum or obiter dicta?
In context, yes, because then it is not the ratio. Yes, usually you tie the facts with the issue and then you make a ruling. And that's what we call the ratio. The ratio is, do you make a conclusion, a judicial conclusion?
Okay.
And the judicial conclusion is born out of the facts or the finding that you have made. And then you then give a reason why you have decided against this party or the other party. But in the course of delivering the judgment, justices will say things that, oh, by the way, this means this, or that, which was what we classify as a obiter dictum. But let me answer the question directly.
Okay.
If so, under normal circumstances, and Sina Malba did indicate that those comments were quite harsh, and I agree that they were quite harsh, to the extent that it is not your judgment, it is not the ratio of your judgment. Now you go on a very, very harsh tone. It's very clear. It's called him corrupt and all of that. And I think that this can be one of the bases on which those who are going on appeal can say, look, we think that, and by the way, if they had issues with the change of justices, they should have done that. The lawyers could have taken it on and then made an application for one of the justices to recuse themselves on the likelihood of bias. And so I do not have specific comments on that, other than to say that, what would the lawyers do with that now, with that obiter dictum? What does it, if you look at it in the circumstances of the case and the ruling, what can the lawyers make of that? Remember, in the field of justice, one of the key requirements is that the judge should not be a judge in his own cause. That is why we're always looking for a neutral
arbiter.
Neutral arbiter. So every judge is presumed to be a neutral arbiter. You have no interest in the matter. That's what it means. But if you make comments that suggest that you are emotional, that you're very sentimental about the issue, and that you is so vexed of the matter, then it can lead to some conclusions that, are you interested in this matter? Why do you go on this tangent? Especially when it is not the gamut of your case or the gamut of your ruling. What informs that? It is not for me to say whether that can lead one to conclude that the judge was biased or whatever it is. It's for the lawyers to determine what they do with that information. But under normal circumstances, a judge must be one that is fair. Okay, judicial discretion must be used having account of Article 296 of the Constitution, that you don't have to be biased. You don't have to be prejudiced against any of the parties. So are those comments prejudicial, or do they lead to the conclusion that they are prejudicial to the manner in the harsh tone that they were used? I mean, this is the comment that I can make on this one. I do not know what they will do with it, but I was quite surprised by the tone of the language. I was quite surprised.
So then the bottom line, in fact, the baseline question we want to ask is whether there's been a travesty of justice from where you sit.
In the evidence that was produced by the court, by the parties, the video, on the basis of which the judge made the decision, I think it would have been difficult to establish that Anas indeed is a murderer. Very difficult. Because no such evidence was led, and no such evidence could have been led to the conclusion that Anas is a murderer, as alleged by Ken Ejapong.
Okay.
So the veracity or truthfulness of his allegation that he's a murderer is in question. I mean, and this is you don't need to be a lawyer to even answer this. That is it true? Because truth is a defense in the civil matter of defamation.
Okay.
So if he could establish that indeed is true, what was the probative value of the videos that was shown in court? What was the purpose of those videos? To authenticate and to vindicate the statements that were made by Kenneth Japong.
Right.
And remember, let me say it again, that the court itself came to 3 levels of analysis that is required in defamation. Number 1, that you have authored statements. Number 2, that those statements have been publicized. Number 3, the publication of those statements are on a person which is Anas Anas. Then the next inquiry is, are they true? And if they are true, then it becomes a defense for the defendant. I'm not quite sure that the court was able or was even in the position to establish that Anas indeed is a murderer and come to the conclusion that no defamation will lie, or that the defendant was not liable for defamation. So in respect of that, I will answer definitely that I'm not sure on the evidence. So there are issues of admissibility of those evidence, there are issues of whether or not the weight that the judge placed on those evidence, whether it could make the conclusion that he made. And that's for the appeal lawyers to look at.
Look, I actually wanted us to end with this, with the question I asked you earlier, but I don't know, but I can't help it. We have about 10 minutes to go. But, you mentioned the case about the obiter dicta, obiter dictum, depending on where you stand. But yes, it was a comment that was made in passing, but Anas has been defamed, hasn't he? Because today when Anas, if anybody knows Anas, they say, you are the investigative terrorist, I mean, the ordinary bystander doesn't know the difference between what an obiter dictum is or what a ratio dissidenda is. As far as they're concerned, a certain image has been created or formed about Anas. What can Anas do to set this image aside? Because it probably may hurt his image even on the international front. Won't it?
Well, definitely. I mentioned earlier that this case is not just a legal issue. It's also a political issue and then an economic issue as well. We've known that the pursuit of anti-corruption, there are few individuals that you can mention in this country, and that is on that tangent, and Anas is one of them. You would wish that all the institutions that are involved in the governance system, the court system, the other investigative systems and all of that can work together with a common objective that we want to stem corruption. So you don't want to take away the energy or the excitement or the drive that someone like Anas Amiyao has to pursue against corruption. And your own earlier videos that you shared, you notice that there have been cases where Anas has been vindicated, be it in Nigeria, be it his alliance, Tiger Ass alliance with Al Jazeera. So there's a social good in his work. There's a social good. That social good must be protected.
All right.
Because it's in the benefit of the public. It's in the public interest that corrupt practices and corrupt individuals and institutions must be exposed, and that the public resources can be protected. That's very, very key.
Okay.
Now, what does he do with this? So to that extent, any judge that is making this comment ought to be aware that it is a double-edged sword. You need to be careful as to what you say about the work of someone that has led to the removal of justices of our court, from magistrates through to the High Court and all of that. What does he do with this? And that is, you see, what he does with this is to appeal, to vindicate not just his process or his methodology, but that he was defamed and that the defendant could not prove by the evidence that was given that indeed is a murderer, or the other allegations that were made against him. And I'm sure the lawyers are very much aware of the processes that I'm sure by now they have filed notice of appeal already.
All right.
The records will be set, and then they will do the written statements to the Court of Appeal, and then we can take it from there.
Okay.
That those statements that have been made against him, do they indicate that the judge had a certain disposition of prejudice against Anas? I cannot tell. Let them go on appeal. And this matter is by no means ended. It's not conclusive. So let's see what he does with all of these obituous statements against him.
All right, Doc, it's always a pleasure talking to you. Thanks for your erudite submission on this particular matter. I'm so grateful that you joined us. We have about 5 minutes to go. So Honorable Abraham Amaliba will give us his take on what he thinks Anas can do going forward, and also the issue about whether Anas should have got the judge to be recused from sitting on the case. But I have two very important messages that I need to read. Some persons who are watching will have a take on this matter. Good morning, Mr. Moro. Judges are human, no matter the level of their supposed erudition. So the attempt by one of your panelists to appeal to the authority of Eric Barr is neither here nor there. It is clear the judge abused obiter dicta in unduly scolding Anas beyond the substantive matter of establishing defamation or otherwise. Again, the lawyers have the distinctions between mens rea and actus rea, which is mens rea, which is the intention, and mens rea, which would be what?
Actus rea is the action.
Okay, the action itself. Okay, so I'm in law school this morning. Elsewhere, what we're condemning as entrapment has been determined as legitimate means of unearthing criminality and underhand dealings, because the intention of the investigator is not parochial, but to unravel such corrupt characters for the public good. So we must critically look at this issue because, like you aptly put it on the show, why should any group of vegetarians be apprehensive and jumpy with an investigative methodology of a journalist going around and tempting people with gifts of goat meat? You know, and it reminds me on the issue about, the Justice Diary matter where the goat was actually tied outside, and then the man saw the goat and he was happy. You know, it's not a laughing matter. It's a very serious issue. But, these are the kinds of things that entrapment can do to us. Goats. I know the kinds of things you can entrap me with. I like books. So when you give me a book, you finish me. You can entrap me with a book. But anyway.
If you ask me whether, a similar question, whether the judgment is a travesty of justice, I would say yes, emphatically.
You've answered that question already.
I would say yes, because looking at the over 30 comments that were made by Kenya Japan, let me just give you two, and whether he was able to prove this.
Right.
Plaintiff is suffering from mental derangement.
Right.
It's one of it.
Okay.
How did Kenya Japan defend this? The next one, plaintiff cheated his way through the law school.
Right.
So if these things are allowed to stand, they clearly would create a damage, permanent damage on the reputation of Anas.
Okay.
So there's a need for the lawyers of Anas to do something about it.
Mm-hmm.
On the issue of whether they could have protested, yes, they could have protested if they knew what was coming. But they never knew that the end would be this way. So they could have, but if you are a lawyer on the other side, and one and one lawyer is pointing at a particular judge to take over a case, it must give you some eyebrows.
It must be cause for worry.
You must be worried about that. So at that point, they should have, as lawyers for Anas, be a bit circumspect and delve into the matter before maybe also refusing to accept him as a lawyer for the case, the judge for the case.
That's interesting. Honorable Abraham Amaliba, or lawyer Abraham Amaliba, is the Director of Legal Affairs, the NDC, joining us this morning for, well, what I call, this is legal jurisprudence, isn't it? That's what we've just done. Right.
Law 101.
Law 101, yes. You know, I've had a lot of people actually send me messages say, look, you have to go to law school. Okay, I'll think about it. I think law is a beautiful subject that we all must pursue. Anyway, my name is Audu Mora. I also want to thank Kingsley Amwakwabuedu for joining us. He's also a law lecturer. And also Dr. Reina Akumpediga. It's been wonderful having you as my resource persons and also as my viewers. Thank you very much for watching. Have a great weekend. Bye-bye.